30 seconds, still going live.
All right, welcome to our committees today. We'll get started with our facility protection.
We'll come to order with C1, please.
Commissioner C1 is consideration of commission approval of signed consent agreements in the resolution of the following GovCon violations A and B.
Questions or comments? And I don't think the sound is up. I don't believe people in the back can. Somebody check that. Can y'all hear anything back there? Y'all hear it okay? All right, good, excuse me. All right, C2, please.
C2 is consideration of staff's recommendation to issue a Rule 9 sign for failing to address a consent agreement in the following GovCon cases A through K.
Any questions or comments on C2? Hearing none, that's it, and there's no regular item, and so the Citizen Protection Committee will adjourn.
Thank you.
So Telecom,
All right, we'll come to order with Telecom with C1, please.
Good morning, Commissioners. Item C1 is consideration of request to cancel AOS certificates of authority for the following companies, A through G. Everything is in order. Staff recommends approval.
Questions or comments? C2, please. Dr. Bowman.
Morning.
C2 is docket 56037, consideration of proposed tariff revisions by TDS Blue Ridge. Everything is in order.
That it?
It recommended be placed on the agenda.
I'm sorry.
It recommended be placed on the agenda.
Okay.
Yeah.
Any questions or comments on C2? All right, C2 is on. C3, please.
C3 is consideration of proposed tariff revisions by TDS Camden and TDS Nelson Ball Ground. Everything is in order. Recommend be placed on the agenda for approval.
Questions or comments on C3? C3 is on. C4.
C4 is dockets number 56024 and 56025. Consideration of applications from Extenet LVS LLC for CLEC and IXC. Everything is in order. Recommend be placed on the agenda for approval.
Questions or comments? Hearing none, C4 is on. We have one regular item, R1, please.
Regular item 1 is docket number 34878, application for Q-Link Wireless LLC designation as an eligible telecommunications area in the state of Georgia. Consideration of initiation of Rule 9SI and procedural scheduling order. Staff is recommending that a initiation of a Rule 9SI proceeding for the purpose of hearing evidence to determine whether Q-Link Wireless LLC has violated conditions of its ETC designation and appropriate action to take based on this determination.
Any questions or comments on R1? Hearing none, R1 is on, and that will conclude Telecom. Thank you very much.
all right, we'll go to our Energy Committee.
Thank you, Mr. Vice Chairman. I'll bring the Energy Committee to order. We'll begin with our proposed consent agenda. C1, please.
C1A, docket number 56031, Southern Rivers Energy, application for financing authority. Southern Rivers Energy filed a request on December 19th, 2024 for financing authority relating to a RES work plan loan in the amount of $46,970,000 with a maturity date of 30 years. Secured Southern Rivers Energy provides service to nearly 16,000 members in 9 counties. C1B, docket number 560, Coweta Fayette EMC, application for financing authority. Coweta Fayette EMC filed a request on December 20th, 2024 for financing authority relating to a RUS Treasury rate loan in the amount of $157,744,000 with a 3-year term. The purpose of the loan is for a construction work plan. Coweta Fayette is located in Palmetto, Georgia, with locations in 8 counties. The EMC has over 72,000 members. Staff recommends approval.
Questions, concerns, comments on C1? Right, thank you. C1 is on. C2.
Good morning, Commissioners.
C2 is consideration of request for transfer of retail electric service by the following customers. I don't think it likes me today. But presented in line items A through B, supporting documents are in order and staff recommends approval.
Questions, comments, or concerns on C2? All right, C2 is on. C3. Got the mics with that.
Good morning, Commissioners. C3 is docket number 55356, 2024-2026 regulated provider of natural gas. Consideration of SCANA Energy's third and fourth request for Universal Service Fund disbursement. SCANA, the regulated provider, filed the following disbursements. The third disbursement for November 2024 for 9,634 Group 1 customers, totaling 45,761.50 cents. And the fourth disbursement for December 2024 for 9,799 Group 1 customers, totaling 46,545.25 cents. For all disbursements, SCANA provided a trade secret monthly customer count Excel spreadsheet and a notarized sworn statement to aid in staff's verification of the amount of Group 1 customers that were served by SCANA. Staff recommends the approval of all disbursements.
Questions, concerns? C3.
Commissioner Johnson, I have a question for Irma. So aside from this particular docket, I'm interested to know if staff tracks the number of customers that are utilizing the regulated provider service on a quarterly basis or an annual basis?
We do have that information. We don't have, I can provide it to you if you add your request, but we don't have an actual tracking that we do, but we get that information every month.
Okay, that's great. I'll send you an email. I just have some questions about numbers of customers served. Thanks.
Okay.
Thank you, Commissioner. All right, C3 is on. C4?
C4 is docket number 25471. Application of Fireside Natural Gas LLC for Natural Gas Marketer's Certificate of Authority. Consideration of Fireside's petition to surrender their certificate of authority. Fireside Natural Gas is surrendering their certificate of authority GM 36 in accordance with the February 29, 2024 order approving the change of ownership of Fireside to Nextera Energy. The transition period has concluded and Fireside is no longer serving any customers in Georgia. Staff recommends approval of the petition.
Questions, comments, concerns on C4? All right, thank you. C4 is on. C5.
Good morning, Commissioners. Item C5 is docket number 15326, consideration of modifying the existing PSC rules concerning Universal Service Fund mandated by HB 1568. Consideration of Atlanta Gas Light Company's petition for a waiver of Commission Rule 515-7-5.072C. On September 1st, 2025, the AGL is scheduled to file a 2026 USF annual plan. In support of this filing, AGL will open a stakeholder survey process to gather information on potential USF projects. Commission rules require that a stakeholder survey is to run from April 1st to June 30th. On January 8th, 2025, AGL filed a petition for a waiver of commission rules to adjust the opening of the stakeholder survey to run from February 1st and to close on April 30th. AGL stated that moving the survey date is necessary to provide the company enough time to fully assess each potential project, select projects to include within the annual plan, and comply with the regulatory requirement to file the USF annual plan by September 1st. The staff recommends approval of AGL's waiver request. Thank you.
Questions, comments, or concerns? C5. Right, thank you. C5 is on.
Thank you.
All right, moving on to proposed regular agenda. We are going to start, Mr. Vice Chairman, with regular agenda item number 2. Mr. Keller. No, sorry, we need staff.
Oh, I'm sorry.
For you. Would have been a unique situation had you gone first.
Item R2 is docket number 4822, capacity and energy payments to co-generators under PURPA, consideration of RGP Bowman Solar LLC's motion for reconsideration and motion for stay regarding petition for extension of time and declaratory ruling on interconnection costs for qualifying facility. On November 26th, 2024, the commission issued an order denying RGP Bowman Solar LLC's emergency petition for extension of time and petition for declaratory ruling on interconnection costs for a qualifying facility. On December 6th, 2024, Bowman filed a motion for reconsideration on the commission's order. In this motion, Bowman argued that the commission improperly refused Bowman's request for an evidentiary hearing to determine the reasonableness of interconnection costs. On December 26, 2024, Bowman moved for a stay of the order to maintain its position in the interconnection queue. Staff has considered the legal arguments made by Bowman's motion, namely that the commission's order was a violation of Bowman's due process, arbitrary and capricious, in contravention of the commission's own QF interconnection procedures, and unduly discriminatory against Bowman by treating it as a network resource rather than an energy-only resource. However, staff does not agree with the arguments made by Bowman and recommends denying the motion for reconsideration. The commission considered the reasonableness of interconnection costs when approving QF interconnection procedures.
You need to speak up. People
I'm
can't
sorry.
hear you in the back. I'm
Sorry. The commission considered the reasonableness of interconnection costs when approving QF interconnection procedures and interconnection agreement documents as they apply to Bowman. They were the result of 14 months of discussion between the company and staff. Further, staff met with both Bowman and the company to discuss the suggested transmission upgrade identified by SCS, as well as potential alternatives. The alternative transmission option did not eliminate the required transmission upgrades. Although staff recognized the QF's right to sell energy or capacity to the company, nothing in PURPA, the commission's prior orders, or the established state jurisdictional interconnection procedures gives QFs a right to an evidentiary hearing. PURPA allows state commissions to assess whether the interconnection costs are reasonable and non-discriminatory. The establishment of clear and comprehensive procedures is how the commission exercises its jurisdiction in the matter. An evidentiary hearing for every interconnection dispute would frustrate the main purpose of PURPA and to provide an efficient means for QF to sell their electricity. Finally, staff also recommends denying Bowman's motion for stay. Bowman has not shown that it will likely succeed on its request for an evidentiary hearing, nor has it shown that it will suffer irreparable harm in the absence of a stay. Even if Bowman's QF project is removed from the queue, there are other avenues for moving the project forward. Does the commission have any questions?
Commissioners? All right, if anybody wants to speak to this item? Thank you.
Good morning, folks. Newton Galloway on behalf of Bowman. I've lost him before. I'll lose him again. But I want to address the motion for recon and also a little bit of the staff recommendation. And before I get started, I want to thank Mr. Collado for his work on this. I don't agree with his result, but he at least respected the petition and the material I've seen this morning and took it seriously and he reached a different conclusion. But it was nice to know that the work had been read. In section 3 of its response to our motion for stay, 3A, Georgia Power made the following comment. Bowman's likelihood of success on the merits is 0. The last time I was told I got 0 was by the head of the math department at Griffin High School in my senior year. If we truly get 0, it means that I have advised Mr. Anderson and Bowman in a way that wastes their time and wastes the commission's time and the staff's time. And I guess because of experience in prior areas, I don't see the waste. My comments today will be a little unorthodox because I want to ask a series of questions to get to the point of what constitutes the request and why a request for an evidentiary hearing should be approved. Because we're not at the merits of the case yet. The only issue is whether Bowman gets an evidentiary hearing on the reasonableness of interconnection costs. That's all we've got. Now, first question, why are we concerned? Why is this commission concerned about interconnection costs? It's because in every case involving interconnection, there is a company that needs something from a regulated utility to be able to do business. In electricity, the generator needs to interconnect with the grid of the regulated utility to sell it power that it can then sell to customers. 25 years ago in telecom, the entity needed network components to provide a public service to third parties. They're different utilities, but the importance of interconnection review is the same. What is the commission's role in interconnection? Because you're dealing with a regulated utility within your jurisdiction, you are the gatekeeper to make certain that the regulated utility treats all generators seeking interconnection the same and that the costs are reasonable. And in electricity, there's one more. And that is cost for interconnection not be placed on ratepayers. Now, we can have all the procedures that we want. We can comply with all the procedures we want, but that does not mean the result is the imposition of a reasonable interconnection cost. How many disputes between a generator and a generator QF and Georgia Power have come before this commission for review to the point of asking for a hearing? This is the first one. Heelstone and Pine Gate are your only other QFs. I think CPV, well, they settled their cases. Mr. Carver had CPV in 2021. That resolved. This is the first one that's gotten this far. And I'm going to make the observation that in my view, it was inevitable that at some point this request would come up. And it comes up because of the amount of the interconnection costs that are assessed and identified in the final study. What standard does the commission apply to interconnection costs between a generator and Georgia Power? Y'all have a one-word standard. Reasonableness. What is the legal authority for that standard? Two orders, 1994 and 2021. I'm going to quote from the 94 order. Page 3. All QFs will pay reasonable interconnection costs subject to this commission's jurisdiction to resolve disputes. One other section from that order, the utility shall inform the QF of the interconnection costs at the time of the contract. However, the commission reserves its jurisdiction to determine the reasonableness of the interconnection amounts should a dispute arise at the time of the contract. Let me ask you another question. Is there a threshold of any sort that the commission has used or adopted to determine when it is appropriate for this commission to exercise the power that it reserved to determine reasonable interconnection costs? The answer is no. There is no standard that's been set. We recognize the factual question that would come up and presented and provided you with expert testimony identifying problems with the interconnection study. But staff has no criteria available to it by which it can assess reasonableness. Where are the guidelines and procedures for resolving an interconnection dispute? Now, I'm not talking about procedures to do the study. I'm talking about the procedure to resolve a complaint or question regarding the amount. There are none. They have never been developed. But yet this commission did when in Senate Bill 137 and Telecom, OCGA 465164 gave you authority to look at interconnection rather, and you had an important docket 5958, where you began to determine what procedures would apply for an interconnection dispute. You didn't finish that because you were interceded by a Telecom Act of 96, which set procedure that you then followed. Next question, do the interconnection procedures developed by Georgia Power in 2021 and 22 that were approved by the commission include a procedure for the generator to challenge or question the findings of the interconnection study? No. They set a procedure for the studies only. They do not have any mechanism for review of the accuracy. The closest document I can find that attempts to reference what may be studied is a document by Southern Company Services, which details some of the study process. In the commission's order, it noted that the interconnection costs have been reviewed by a desk review of costs by staff. What is the authority by which a desk review of interconnection costs by staff to resolve a dispute is deemed to be appropriate? We have none. Now, what is the interconnection requirement imposed on Bowman in the Phase 2 study? They have to rebuild on their own 35 miles of 115 kV lines. All of those lines are already 90% or above loaded. They are to incur that cost alone, and some of those lines have been added to a 10-year plan for upgrade with a cost of $66 million for those. So with that in mind, what are the specifics that we requested in relief? Number one, to have you determine whether it is proper to impose those costs solely on Bowman when others benefit. The FERC rule provides for the proportion of costs among beneficiaries. And I would argue that that is a policy decision for y'all. That is not a unilateral decision for Georgia Power to make. Secondly, whether the upgrades are required and whether the costs are reasonable. And we requested also that you look at setting a standard for evaluation of interconnection cost, not the procedures, but the costs found to resolve the issues that we raised in the petition. I don't see those as being an unreasonable request. We filed a petition based on the declaratory rule this commission has, and that is based upon a statute in APA, OCGA 5013-11, which provides that a declaratory action is applicable to any rule or order of the agency. And in your rules, it provides that it is appropriate when you're having to interpret an order of the agency. And the only thing that's governing interconnection right now are the two orders you have from 94 and 21, and one word: reasonableness. I acknowledge that the commission's rule gives it discretion, but your discretion is not limitless to hold a hearing or not hold a hearing. You cannot abuse that discretion, and y'all know it, and you take that responsibility seriously. You cannot act arbitrarily or capriciously. So as we sit here today, there are no rules governing the review of the actual QF interconnection costs. There are no procedures to challenge the costs. You have statutes and procedures that address interconnection disputes for the other utilities that are regulated here, and you have held numerous hearings on interconnection for those other utilities. I recounted that Ms. Lindell and I were involved in about 18 of those. In the other interconnection disputes, you deemed the action to be a contested case and set a hearing schedule. There is no authority that says a desk review is sufficient to resolve an interconnection dispute. And there is no guidance for the staff by which its evaluation of reasonableness would occur. And to not allow a hearing and approve a desk review is not allowed with other utilities that have interconnection requirements. I do not understand the distinction between what we had to deal with 20 years ago in other utilities and what is facing the commission now. I just don't see it. And that may temper the way I see this differently from others. And if I'm wrong, I'm wrong, but I don't see the distinction. And I have to believe that if the parties were reversed, Georgia Power would be making the same arguments that I'm making today. So let's look at the motion for recon. As Mr. Collado said, in our motion for recon, we cited as an argument that the failure to conduct a hearing renders the order arbitrary and capricious. Arbitrary and capricious is a high standard to meet, but it is possible. Arbitrary and capricious was used as the basis of the Ninth Circuit's review of the FCC's denial of certain services to MCI when Telecom was trying to become a competitive industry. There are circumstances where it is appropriate, and with all due respect, this order is arbitrary, and in my opinion, meets the standard of arbitrary and capricious. In asking for a stay, we gave you an affidavit testimony from Mr. Anderson, who detailed his efforts to try to comply with the order that denied the hearing. If the stay does not occur, Bowman has to start over, make a new application, be replaced in the queue, and the expenditures of $1.3 million that have already been spent will be lost. And I cited to you a case in the motion for stay, Green Bull Georgia Partners versus Register, which makes the distinction between success on an appeal versus success on the ultimate merits. And that allows and identifies the reason why his stay is appropriate, or a stay in his case is appropriate. I want to make one final point. I do not believe that QFs are going to go away. And I know it is not a favored form of generation for Georgia Power, and I know in many instances y'all consider it a hassle. I don't know how I became the king of QFs, but it fell on me. And I have tried to fight a respectful and good fight. But if RFPs, as I'm advised anecdotally, are not being fully subscribed, those megawatts are not being used, if that is true, and I do not know. But to compete in an RFP now, huge tracts are required to get to competitive prices. I know that from working with landowners and working with folks who are trying to lease land. Huge 2,000 and 3,000 acre tracts in South Georgia are declining in number, and to get their zoning approved is a brutal exercise. I have been called every name in the book in zoning hearings representing a developer. Well, not all of them. Lyndall can come up with some that I hadn't been called. And I don't understand why the RFP process is touted as a panacea. The Bowman project's been studied. They have determined a total of $76 million in interconnection costs. If Bowman were to go into an RFP, do those interconnection costs go away and disappear? They've been determined to be applicable to this project. And I don't believe there is likely any way that a bid project with $76 million of interconnection costs makes a short list. And at a size of 80 megawatts, I don't think it can be price competitive. So I do not see the RFP process as the panacea. I would urge the commission to reconsider its decision and hold a hearing on the issues that I've raised on behalf of Bowman. And I am of the belief that an appropriate QF interconnection process would bring this to a manageable conclusion without having to have multiple QFs having to come up here on a piecemeal basis, one at a time. Thank you. I've got any questions, I'm happy to answer.
Galloway,
Yes, sir.
boiling down to your request for hearing, et cetera, is it because of the disagreement, whether it's a network resource or whether it's an energy-only resource? What is it, the cost of interconnection?
Commissioner, both are asserted. The issue of whether it's network or energy is a legal question and how that plays into interconnection. I did not address the legal questions today. Factually, the question is the cost that's been imposed in the QFIA as a result of the study, which I've identified to you. So both are there. They have different impacts on the case and they play different roles in it. All right. Thank you.
Commissioner Pridemore?
Thank you, Commissioner Johnson. Actually, I have a follow-up for staff. So Mr. Galloway made some pretty strong accusations in his argument related to two previous rulings of the commission, one in 94 and one in, I think, 21. And I am certain that staff considered those in their recommendation, and I would like for them to walk us through those legally. And also, too, the concept that a desk review of a filing isn't sufficient when a desk review by staff of a filing is how staff builds testimony, how they consult with commissioners. I want to give staff the opportunity to talk through that, please.
Jamie, do you want to talk about Jamie was actually part of the group. Yeah.
Okay, Commissioner Pridemore, you are correct. Staff has been working on this issue for over 2 years. So a desk review is probably putting it very lightly. But obviously, when Georgia Power submitted these studies, my team met with them numerous times to go through these upgrades. And when Mr. Galloway saying interconnection costs, he really means delivery related costs. And this is getting the energy to the customers. We have met with them numerous times. We reviewed the studies. We talked to RGP Bowman as well. And so we looked at their alternative. The biggest issue, and I don't really want to get into a lot, I think Georgia Power will get into this, is that they interconnected, where they're interconnecting is causing a lot of this. And one thing that I do want to point out is some of these costs that Mr. Galloway is saying that his client is paying, now that Georgia Power did make a concession and say, when you first got studied, these upgrades were not in the 10-year plan, but they are now, but they still have to post security. They're going to get that security back when the upgrades are completed. And so technically they're not paying for them. They're posting the security for that. Then obviously we have the affected system that they were not able to reach an agreement. In order to protect Georgia Power customers, they must post security for that. And that is part of the bigger issue is this. If they had been able to work out an issue with GTC, they would not be required to post security for those calls. So, and obviously Georgia Power determined what those costs are. So staff has put a lot of resources into this. It's, we did put in our backup. We've done a desk review. We looked at all this. John and Bobby looked at, it wasn't just that. It was a lot of work for us. You want to? Okay.
Yes, and forgive me, Commissioner, if you could just restate your first question about it was the interconnection procedures.
Mr. Galloway made two claims that prior commission decisions, I believe that they were in years 1994, and I think 2021. He cites that it's based upon the commission's decision that gives argument to why he should get a full hearing for his client. Talk me through why those are or not applicable to his argument.
Sure. So I don't have the exact orders in front of me, but I believe that the language of both of those were that the commission reserves the right to determine the reasonableness of the interconnection cost. No procedure in doing so was ever prescribed. So mostly we were looking at the purposes of the original statute on how it would allocate like the way interconnection costs are allowed. And in doing so, we found that, well, mostly that we're sorry, forgive me. It's the staff's position that the interconnection cost can be set by procedure, and that procedure is how we set the reasonableness. So the reasonable procedure gives a reasonable result. And in situations where the commission wants to jump in and actually set and grant a hearing, it absolutely can. The question, I think, in this petition is whether or not the petitioner has a right to request a hearing, and we believe it does not, because that would frustrate the purpose of PURPA in granting an efficient way for QFs to enter into the system without causing any undue cost either to ratepayers or any costs to slowing down the process.
Thank you, Mr. Collada.
As Ms. Barber stated, a lot of time has been spent with staff, and I'm sure the Mr. Galloway and they said, is there anything that we're afraid to have a hearing about?
No, Commissioner, I don't think there's anything we're afraid to do. I just think it'd probably be, I don't think that it would necessarily change the result. We don't really see anything that a hearing would change, and we think that it would probably really, we could relitigate the actual matters about how the studies were done, but at the end of the day, the company does a review on the grid and they're in the best position to do so. We're looking at that, and we do perform a desk review. That's not prescribed in the statute that we have to do a desk review, but we feel like we did a good faith effort in looking at all the different options here, and going into an evidentiary hearing wouldn't, I don't think, yield any different result.
Commissioner McDonald, I think there's a very good reason for us to have this hearing. To your question, and it's the IRP that is about to be made public at the end of this month. I think we've got an enormous amount of energy that we need, and there's been a lot of money that's been spent on this project, and this isn't just any client of Mr. Galloway. This isn't some California solar firm coming in here from San Francisco. This is Mr. Anderson, who lives in Athens, who coaches cross country at Athens Academy, who has been before us before with QFs, with biomass. It's got a long track record with us, and they made, I think, a good appeal this morning for reconsideration, and I think we should hear it. I mean, we give full hearings on railroad cases and other things when we need to look at it a little bit closer. And an 80 megawatt project is substantial. He mentioned the zoning. I'm seeing more and more rural areas adverse to solar out there. This one is ready to go. We just got to get our arms around this interconnection. And I think because it's so far down the road, that we owe it to them to reconsider our action, have the hearing, and really look at this close. By the time we do have the hearing, the IRP will be here. We'll be able to factor all of that in to whether we make a move on this or force a different condition. So I just feel like we need to have the hearing.
All right. Thank you, commissioners. Anything further from the commissioner? All right. Thanks, sir.
Good morning, Commissioners. Allison Pryor on behalf of Georgia Power Company. I'm going to start with responding to Mr. Galloway's request that that Bowman is due an evidentiary hearing, and I will also address Commissioner Pridemore's question about the 1994 and 2021 orders. So Bowman claims that it has a right to an evidentiary hearing, however, to challenge the reasonableness of the interconnection costs. However, that claim is incorrect. Bowman filed a petition for a declaratory order. There is no right to an evidentiary hearing when you file for a declaratory ruling. That decision is entirely within the commission's discretion, and your commission rules direct that if there is no dispute with respect to any material fact, and unless the commission so orders, which it has not, no evidentiary hearings shall be held. To Commissioner Pridemore's question about the 1994 and the 2021 previous orders, those were both contested cases. Those were not issues of a declaratory ruling. In 1994, the commission was deciding how to set up payments, how to pay PURPA QF generators. That was the whole underlying base original filing. How are we going to pay these generators? In 2021, the commission reevaluated its avoided cost methodology. It had a contested case where it invited participation from other parties and interveners onto how QF generators should be compensated. That was a contested case. In a contested case, you do get a evidentiary hearing. We have contested cases for the IRP, as you mentioned, Commissioner Eccles, and for rate cases and other types of cases. This is not that. Because there is no right to a hearing based on the way their petition was filed, the commission's decision to deny its request for an evidentiary hearing that you already made is entirely within your discretion. No reconsideration is necessary. In terms of the reasonableness of the interconnection costs, so on the merits of the claim that Bowman is making. Regarding Commissioner Pridemore's question as to the desk review, I would reiterate from the filings in this case that 3 separate interconnection studies were done to evaluate the costs and the necessary upgrades needed to not only interconnect this facility, but also deliver the power that's eventually generated.
Done by who?
They were done by Southern Company Transmission Planning Engineers. I will also note that alternatives were evaluated. Both the company evaluated alternatives, the commission staff weighed in on this, even at Bowman's request, please evaluate alternatives. They were done. They even approached a different ITS participant, GTC. Can we do this differently? Can we do this cheaper? The answer is no. Although the alternative reduced the overloading on the transmission line in question, it did not remove or eliminate the need for the upgrade. So to upgrade, these costs are needed regardless of whether an alternative solution was available to them. At base, Bowman's claims about having a right to develop a QF facility, that's not contested. Nothing that the commission or Georgia Power has done is prohibiting Bowman from developing this facility. Mr. Galloway acknowledged that when he was speaking here just a moment ago. If they want to continue with this facility, they can re-enter the interconnection queue. They can participate in an RFP. They still have options. Nothing about your decision on this request prohibits this facility from continuing on this path. Okay. The merit question of whether the costs assessed to Bowman for interconnection and uninterrupted delivery are reasonable. As the staff's recommendation makes clear, as does your prior order, Georgia Power followed the commission's approved procedures for qualifying facilities. The costs are reasonable. Bowman's claim that these costs are too high ignores that these are real costs assessed after a thorough review by Southern Company's transmission engineers. Interconnection and transmission are expensive, and it was Bowman's poor siting decision that led to the high cost of this interconnection. PURPA requires that all other customers be held harmless and neutral from the purchase of electricity from a qualifying facility. That means that other customers should not have to pay more for electricity because of Bowman's project. If Bowman does not make the required payment or post adequate security, which as staff mentioned, they get back eventually for these projects, what happens if they walk away in a few months, in a few years? Georgia Power's retail customers will be left to pay for those transmission projects. That outcome is not allowed under PURPA. So I just wanted to clarify those points that have already been addressed today. In addition, regarding the motion to stay, Bowman filed the motion to stay to avoid being found non-compliant with the commission's prior order and obligation to pay these interconnection costs and post security for these network upgrades. The costs were due on December 26th. Rather than making these payments, Bowman filed for a motion to stay
pending the outcome of its motion for reconsideration. Because the motion for reconsideration should be denied, so too should the motion for stay. Georgia Power's written response details all the additional legal reasons why the motion for stay should be denied. And I won't bore you with those details here. But because there is no reason for the commission to reconsider its prior decision, there's also no reason to grant the stay. Georgia Power appreciates staff's thorough review of these issues and claims over many months, many years, and agrees with and supports staff's recommendation that both motions should be denied. Thank you. I'm happy to answer questions.
Commissioner? Thank you.
Thank you.
Now, I got one more question. So Mr. Barber mentioned something about the security deposit and the
Yes.
fact that now that a portion of these costs is in the 10-year plan. So is that the portion that they post the security as normally required, but then they would get that back? Is that true?
That's my understanding, correct?
Thank you.
One more question.
Yes.
When this IRP is released and we see how much solar and storage Georgia Power wants, there is a chance this cost could come down based on the location of some of those projects, right?
I don't believe so. So because of where this facility is located and the specific aspects of the transmission system where they have sited, without knowing where any other future facility is located and the impact that that would have on the system, that's not necessarily going to change the costs for this facility to deliver the output from it.
But if there are other projects that decide to locate in the vicinity,
They would face probably the same costs or very similar costs because of the needed transmission upgrades in order to deliver power produced from any facility in this region.
so thereby
To get to
sharing
Lake.
some of the costs of reducing Bowman's overall cost, right?
Not necessarily. One project may not be able to move forward if others, for example, they couldn't all necessarily interconnect at the similar location. There may be a first come, first served. Not every facility can locate in the same location and each of them move forward. One might necessarily be served first, and because it is on the transmission line, then producing power to be moved to load, others may not be able to interconnect and deliver on that same line without further upgrades.
And we are going to do an update on our transmission plan during the IRP, right?
Yes, sir.
So we could make changes there as well.
Yes.
Did you say that Bowman had options? That there are other options that they could take?
In terms of the interconnection costs,
Options, period.
yes, Bowman can re-enter the queue at a later time. The benefit of doing that is that those transmission upgrades, which have been identified in the 10-year plan, that would give time for those upgrades to be completed so that the interconnection costs and delivery costs to Bowman would be lower by waiting, right, until those transmission upgrades are completed. So they could wait, re-enter the queue later. They could also participate in one of the company's RFPs.
I want to hear from Mr. Galloway.
Thank you, Mr. Pryor.
Yes, sir. The same question,
Same question. Options.
the options? As presently presented, Bowman, in my view, does not have an option without starting completely over. And
Is re-entering the queue starting?
yes, you would have to have another agreement. They would have to go through the interconnection process and you have to start over.
Will they lose that $1 million?
Yes. Yes. Now, I do want to, Commissioner Shaw, can I address your question on security?
Sure.
During this process, Georgia Power made a decision that its network upgrades could be added to a 10-year plan, which gave them flexibility to offer the option of posting security rather than paying post the security. As we've detailed in Mr. Anderson's affidavit on the motion to stay, no creditors will do that. No financiers will do that. And the reason is twofold. Number one is the size of the security interest. And number two is the duration, because it would be sitting there as security until 2031. So no financer is going to post that security for that time. I want to say one thing about the 10-year plan, because as I've worked through this and tried to analyze what options there were. And let me also say, Mr. Hewitson and I tried to work through options to get us away from having to be up here to fight, but it couldn't be done. From my view, if a project is in the 10-year plan, that is sending the signal that everybody in ITS knows that line needs to be redone or rebuilt. So then the QF has to post the cost for something that is supposed to be done anyway. And then that security is held for years before it's released. To me, the identification in the 10-year plan is confirmation that everybody knows this line's got to be improved. Now, excuse me. So the 10-year plan, Commissioner, there is a benefit to being able to post security rather than writing a check for a huge number amount, but thus far we have not been able to find anybody that's willing to take that security risk. And Mr. Anderson's worked with, I've been on calls with 3 financial partners, one, all of them, and he still has one that's asking questions regarding security. But thus far, nobody with financing capability is willing to post that. And that is a problem with the amount. I want to make it clear, I'm not challenging, Bowman is not challenging in any respect the orders that the commission entered in 94 and 21. We support those orders. But again, there's only one word there, and that for a standard, and that's reasonableness, and that's up to you. And I reiterate, you can follow all sorts of procedures. And these are procedures Georgia Power drafted and that you approved. So I would assume they would follow them. But following the procedures does not mean you reach a result that is reasonable. It may. And let me also say, we presented affidavit testimony from 2 experts that have worked in interconnection with Georgia Power, with Southern. And they've identified several issues. If this were a court case, that would be enough factual support to say you don't get out on a motion. Now that we don't deal with evidence, and we have, let's just say we have different rules up here dealing with evidence and some procedure. But you're presented with solid fact questions about the propriety of those findings. And your discretion is not limitless. You are bound by standards. Like I say, it can't be arbitrary. Your decision can't be capricious. And that's the reason I say that I think the denial of a hearing is a problem. And I'm not here to just take up time. And it wouldn't matter. You talked about Mr. Anderson being a fine, upstanding citizen in Athens. I would say the same thing for anybody who was confronted with this. So I appreciate your time.
Thank you. Mr. Chairman, I've got one more question from, not you, but from staff with Georgia Power. One, what demonstrates the upgrade, the 10-year plan? What's there that says we got to do this? Is it in the growth area? Is it the transmission lines that are there now? Are they in bad repair, whatever, what is the cost for an upgrade for the 10-year plan? And that's
Exactly what you said, but one thing that I do want to point out that Mr. Galloway didn't mention is that although a project is in the company's 10-year plan, it could come out the next year. That does not mean that has to be the solution that is done to alleviate the problem. Hence the reason why the commission requires QFs to post security until it's done. It's because once Georgia Power commits to do the upgrade there, and then they walk away, then that puts customers at risk because they may have had another solution that could have fixed it cheaper or a different location. And so you're exactly correct. The 10-year plan changes every year, right? Projects can come in or come out. And I mean, there's a lot of issues on this is that when a QF is studied, by Georgia Power are trying to work with this project to say, okay, this was not the situation when we studied your project, but since it has come in, we're going to give you this benefit. We have to be careful that we don't start that as the going forward, because that is not the process. Once the project is studied, those are the costs allocated to a project. And generally, we don't have 2 years that we're still dealing with one project. So that was actually something the company worked with at staff's request of, hey, since this project is in here, they're required to post security, but they'll get it back. That is what the commission approved procedures say. That was a litigated proceeding. And as you guys remember, as commissioners remember, QFs were more than welcome to come in during that process and file testimony, come back and say these processes are not good. And some of them chose not to do it.
Mr. Chairman, and from my perspective, I'm not want to do anything that's going to put upward pressure on our ratepayers. Whether it's the cost causer or the beneficiary of the cost or whatever, our ratepayers are loaded. 6 months from now, it may, as you've heard me say before, there may be a difference because we're going to have a new sheriff in town, and there's going to be a new energy policy in this nation that we can hopefully all benefit from. That those areas, Mr. Chairman and Chairman, what my reasonableness is on this, I just said.
Thank you, Commissioner. Thank you, Jim. Does anybody else wish to speak to this matter?
I'll step R2.
Which is R2. All right, R2. You good?
Okay.
All right, R2 is on. We'll go proceed with R1. Oh, wait a minute.
To the chairman here,
Okay.
Mr. Chairman, it's 10:28. Are we going to continue with?
Bob, you're gonna need more time, I'm sure. Why don't we just go ahead and knock out R4? And then we'll come back and finish. Then we'll suspend, allow us a chance to get, I know y'all think we're important, but I don't think the legislature and the governor's gonna wait on us to get to the state of the state.
All right, we'll move forward with R4.
Morning, Commissioners. R4 is docket 56002, Georgia Power Company's 2025 Integrated Resource Plan, and docket 56003, Georgia Power Company's application for certification, decertification, and amended demand-side management plan. This is for your consideration of staff's proposed procedural and scheduling order. At the end of the month, Georgia Power will file applications seeking approval of both its IRP and DSM. Proposed schedule requires Georgia Power to file direct testimony on February 28th with subsequent hearings on March 25th through 28th. Interveners and public interest advocacy staff will file separate direct testimony on May 2nd and May 5th, respectively. On May 27th through 30th, the commission will conduct hearings on the direct cases of PIA staff and intervening parties. On June 9th, Georgia Power will have the option to file rebuttal testimony with hearings on June 23rd through 25th. Briefs in the case are scheduled for July 3rd. The proposed order presented identifies issues to be addressed. pursuant to the IRP Act and prior commission decision, and establishes procedures for interventions and hearings. Staff recommends commission adopt the proposed order.
Thank you, Mr. Trump. Is anybody else? Oh, anybody else? Anybody wish to speak to this item? And then our four is on. Oh. Excuse me. That's three is on.
It was, sorry for it.
Yeah. We're gonna suspend.
Well, let me just say, was there anyone here that wanted to address the commission as public witness, public comments before we leave? Okay, if that's all right with you, Mr. Chairman, let's give us a chance to get over there and
Are we gonna reconvene?
we will suspend and we will reconvene. I don't know how long that thing lasts, probably an hour. Y'all good with, you think we can do it at 12:30?
12:30 should be good. No?
I mean, I would say 9 o'clock, just to make sure.
Same. All right, we're gonna suspend and we will reconvene at 1 p.m.
All right.
All right, we'll get back started with our Energy Committee. And let's see, I'm confused. We did 2, we did 4. So we go back to 1. Thank you, audience, for helping out here today. So we'll go with our 1.
Item R1 is docket number 45084. This is Georgia Power Company's CARES 2023 utility scale RFP. Consideration of revisions to the pro forma PPAs. Commission's December 19th, 2023 order in this docket approved the final drafts of the CARES utility scale RFP documents and pro forma power purchase agreements. The RFP currently seeks to procure 2875 megawatts renewable resources with anticipated in-service dates of 2026, 27, and 28. During the evaluation, the competitive tier bids for this RFP, Georgia Power identified several long lead time transmission projects required to provide firm transmission service to most of the proposed facilities by the expected commercial operation dates. In order to avoid releasing what could otherwise be viable bids, the company has thoroughly investigated all available alternative solutions in order to keep a majority of these competitive tier bids active and under further evaluation. In the company's January 8th, 2025 filing, in order to bridge the gap between the facility's commercial operation and completion of the network upgrades required for firm transmission service, the company has proposed to introduce the concept of short-term network service as part of the PPAs. Short-term network service is a non-firm transmission option which has been used by other utilities that will accommodate the difference in construction durations between the proposed projects and the long lead time infrastructure projects. The company expects this short-term network service to only be used during the first few years of any selected PPAs. Revisions to the PPAs were filed with the Commission for staff review. The output of the portfolio of any selected resources that are procured through this RFP are anticipated to be used to supply the subscription requests of commercial and industrial customers participating in CARES. To the extent the implementation of short-term network service causes an increase in costs under the PPAs, Georgia Power proposes to recover such costs from projected subscribing customers. Georgia Power will estimate such increased costs to recover from projected subscribing customers as part of the CARES program charge. Staff has met with the company on several occasions to better understand the impacts of the resulting RFP portfolio. If this network service was not included as part of the PPAs, staff recommends approval of Georgia Power's request and that the PPA, any proposed cost recovery mechanism for increased costs under these PPAs be recovered from subscribing customers through the applicable CARES program charge. Thank you.
Commissioners. All right, anyone else want to speak to this issue? Yes, thank you.
Good afternoon, Allison Pryor on behalf of Georgia Power Company. I'll make this quick. Georgia Power supports staff's recommendation. The commission, excuse me, by approving the company's request here to incorporate changes to keep the to modify the pro forma PPAs to accommodate short-term network service, will keep more bids under evaluation, and will bolster the success of the CARES 2023 utility scale RFP. And we support staff's recommendation that the commission approve. I'm also happy to answer questions to the extent you have any.
Questions? Thank you, Mr. Paul. Anyone else wish to speak on this issue? All right, let's see, we did 2, 4, 1. Can I have some help here?
Yeah,
Three?
we'll go to 3. So good afternoon. Item R3 is docket number 44280, Georgia Power Company's 2022 rate case, staff's recommendation on revisions to Georgia Power Company's rules and regulations. On December 11th, 2024, the Georgia Power Company filed a request for approval of revisions to the company's rules and regulations. The company cites its unprecedented anticipated load growth and the need to protect customers in the event large projects do not materialize as the rationale behind this request. The rule changes apply to new customers with 100 megawatts or more of load connecting to the system, requiring additional terms and conditions for those customers to allow the company to appropriately assign costs to the customer. The provisions allow for minimum billing requirements and longer contract term lengths for these new customers. The specific rule changes are included in the backup. Staff recommends approval of the company's request with the following modifications. The company shall exercise the discretion under the rules and regulations changes in a manner designed to protect existing customers from bearing any of the costs of adding these large customers. The company shall provide staff with the terms and conditions intended to implement the revisions to the company's rules and regulations and the criteria for applying such terms and conditions prior to utilizing them for contracting. The company shall file the complete contract and associated exhibits, attachments, terms and conditions on all new contracts within 30 days of execution. The company shall make a compliance filing of the relevant tariffs for applicable customers to reflect the changes to the rules and regulations. The commission shall continue to review the issue and may modify the rules and regulations or take other actions necessary to protect the company's customers. Staff reserves the right to recommend further amendments to the company's rules and regulations. Staff recommends that the commission issue an order approving the revisions to the company's rules and regulations with the additional recommendations from staff.
Commissioners, questions?
In layman's terms, this is a process to address possibly data centers coming to Georgia. Is that a fair statement?
Yeah, almost all of the customers over 100 megawatts would be data centers.
So that would assume that any, as we discussed earlier this morning, interconnection fees, security deposits or bonded for in case they came and left in 2 to 3 years, and would leave that cost of interconnections, et cetera, to the ratepayers.
Right. Yeah, this is to protect against if Georgia Power goes and builds the infrastructure and then they leave without.
I've heard staff say that, and I want to hear Georgia Power say it.
Okay.
What do you think, these proposed changes, how will they affect large load customers that would meet this criteria that have already been either served or signed up to serve?
So, yeah, this applies to new contracts.
We can't grandfather, unfortunately.
Early folks get the good deals. I'm glad to hear we're making these changes, and we've got to protect residential ratepayers on this. All right, other questions, commissioners? Anyone from the audience wishing to speak?
Afternoon. Got a letter that I'm not sure. It's in the back up. Bob Sherrier on behalf of the Southern Environmental Law Center. As you just heard from staff, the proposed rule changes here about protecting customers. On Friday, we filed this letter asking the commission to take 2 further actions to shore up the protection here. Our first ask is that you affirm and formally adopt as a policy of the commission that the recruitment and service of large load customers should not result in increased costs for existing customers. Now, we believe that this aligns with comments made by all of you during the IRP update about protecting existing customers from subsidizing the new large load data centers and from the risk of stranded assets.
Before you get too far with this, I want you to revisit the word recruitment. That when you say recruitment, are you talking about Georgia Power recruiting, or are you talking about the Governor's Office of Economic Development recruiting, or I need to know where you bring up recruiting. We don't recruit.
Georgia Power's making competitive offers to customers to win their service under the Territorial Act.
That's under the Territorial Rights Act, and that's because large load.
Yes.
And they have a right to pursue those large loads under the present law.
Yes. That recruitment, not the state economic development, not the state economic development office, but that specific kind of recruitment to become Georgia Power customers.
All right, but how are you using the word recruitment in your letter, so to speak? You're saying we can't recruit, or what do you say?
I'm saying that when Georgia Power is making personalized offers to these customers, that those costs should not be borne by other existing
I
customers.
totally agree. Yeah. And it's what I said a while ago. I want to hear Georgia Power say that.
I would hope this is not controversial for Georgia Power. The
I don't think it is.
The most discussed topic last year during the IRP update was, what if this load doesn't come as you think it will? Who is on the hook for it?
Well, that's where security bonds or security levels of credit from strong financial institutions are going to back up the company's proposal to be in a area with power that has reliability. And that's what they're looking for.
I think that would help a lot. It's related to our second request, which is for increased oversight of these contracts. And the analyses that go into them. So
You mean from our staff?
from your staff, yes. The amount of money that's now at stake to connect these customers is massive and throughout this time of growth for the state. The decisions are being made now.
What's expected out of oversight? What do you mean by that? Is it a in-depth study or is it walking with them every day? I'm just, when you take staff, our limited staff, and that you want them to have oversight in this, I want to know what determines and what length of oversight you're talking.
Yeah, so to illustrate that is this map here, the QTS Fayetteville facility. This map was in our letter. This is one massive data center. The transmission projects on this map represent hundreds of millions of dollars of bill payer money. And so kinds of things that we're asking the commission and the staff to do is to find out how much is QTS paying for this? And how was that amount determined? How much are the rest of us paying for these lines? So I think that increased oversight of these contracts could help identify issues like that. That's what we're referring to, but it can include other things as the commission sees fit and as staff sees fit when they start looking at these closer.
Would this not be something, Rob, that Georgia Power and Surveillance Report would have to bring to staff?
Surveillance report, IRPs, yeah, and ultimately for recovery through the rate case.
Can I also make sure that we're not forgetting about the interim IRP provisions that were put that Bob seems to have forgot, which is the analysis of all these data center projects and the load that's supposed to manifest from that is under a 90-day review period, in addition to the contractual obligations that were put between the company and the customer. Do y'all not remember that, Bob?
Thank you, Commissioner. We do remember that. These costs here, like these transmission lines, we don't believe are included in that downward pressure analysis. And so when we're making decisions now, whether to build these or not, we think that the commission ought to be taking a close look at that because we are talking about billions of dollars.
But Bob, that's the assumption that the commission doesn't look at that. That's the purpose of a rate case. And I'm just not following you here. And remind me too, who are you guys representing this now?
Ourselves, Southern Environmental Law Center.
Okay.
And so
go ahead.
One thing that I don't think has really been explained is what are these companies paying directly for this infrastructure? So the way it's been described in the filings is there's a difference between local and upstream costs. And the local costs are assigned directly to the customer, to the data center. The upstream costs are paid for by everybody else. The way that it's described in the documents is that local costs that are assigned to the data center are only for projects where they are the sole beneficiary. So if a project benefits anybody else, it can be charged to all of us. And it's not clear whether that's the right approach when we're talking about the scale and the magnitude of these investments. How do you draw that line and where? Because if you're connecting this directly to a data center, is that a local cost? How much of that are they paying and how much are the rest of us paying for that? And those are the kind of answers that we would hope to understand before we build, before it's too late, before we overcommit in some of these constructions.
But Bob, that's the purpose of an IRP. I assume you guys are going to intervene in the IRP,
Yes, we expect it'll come up there as well.
but that's where it comes up. I mean, there's a regulatory process for this. I mean, that you all have readily participated in repeatedly. I don't understand why this is coming up different and unique to that. That I'm not following you. I mean, I don't know, this kind of wax political to me.
Georgia Power is requesting to change its rules now, outside of that rate case, outside of that IRP process. That's why I'm here.
But the rule set is the same. I mean, we are talking about the last item on today's energy agenda, correct? I mean, the rule set's the same.
They're asking to make changes to the rules of service, and in their filing this morning said that they plan to file new tariffs with new terms in them.
But they would file them as part of the IRP, Bob.
I think
I mean, we're going to have an evidentiary hearing on all this.
Well, that's
right.
Yeah, that's my point, though, that these sorts of decisions ought to be made in the full context of a rate case.
I'm still, they already are. That's what I'm not following you. There's already a regulatory process in place that Southern Environmental Law Center readily is involved in.
We consider this an ongoing part of that, I guess I would say. This was filed in the 2022 rate case docket. The request from Georgia Power to change its rules of service for new large load customers. And that's what we would like the commission to give some more guidance on that, about how these costs are allocated and divided between customer classes and customers.
But if that was put in the 2022 rate case, why is Southern Environmental Law Center just bringing that up now? One. Two is, if the time and place that this would be discussed is in a rate case, then why are we getting into the weeds of a rate case before it's time for us to have an evidentiary hearing on a rate case? I'm sorry, I'm just not following you.
Yeah, we had the same questions when we saw this filing, because during the IRP update, Georgia Power said that it had the tools it needs under the current rules and the current tariffs. It is now asking to change those rules and tariffs. And so that's why we're up here to ask for additional oversight under the commission's rate-making authority.
I think we have the same results at the end of what we want. We don't want ratepayers paying a bill that they don't have anything to do with. It's how we get that.
Right.
Is what we're arguing about now. And I think we need to hear from Georgia Power on that, and maybe some more from our staff on this. I'm not totally, I'm like Commissioner Pridemore, I'm not totally clear, but the objective is the same for me.
Yes, sir. The rules and regulations that are asking to be changed here by Georgia Power, it's under these where they are making the decisions about how much of that transmission line is paid for by the rest of the customers.
Well, I go back to the same question that I had this morning with Mr. Galloway. How much of that line is necessary for the existing customers for what's it going to take to upgrade it in order to be served this data center? That's the issue right there.
That's a major piece of what we're asking about today.
Thank you, Bob. I think I'm following you more now. Okay, thank you.
See if I have anything else that I wanted to add. So yeah, the key is under these rules, when a customer choice contract is created, Georgia Power is making an individualized offer to that company to try to win their service under the Territorial Act. When they're making that offer, they're making a lot of choices about the profitability of individual customers, about their capital contributions to things like infrastructure. They have to decide, okay, we're going to make your rate this so that we recover these costs. We're asking, what are those costs? Because the level of investment that we're seeing to hook these data centers up is on a different scale than what we've seen in the past. And that's what we would hope a policy of no cost shift here would help guide those decisions, and increased oversight would help make sure that we're making them correctly until we can get to the full rate case process later this year. Unless y'all have any questions, I'll let others speak to this because we appreciate it. Thank you.
Maybe call back.
Good morning, Commissioners. Brandon Mars on behalf of Georgia Power Company. Let me say we also received SCLC's motion earlier this week, and I will address the points raised here today. But as Mr. Scherer did, I did want to make sure there were copies of what we had submitted this morning in response to that motion, so the Commission does have hard copies of our response. You know, I think we want to simplify what we're doing here today. I think we're complicating it, and I'm not suggesting LCC is trying to make it complicated, but there's two questions in front of the Commission. One is, should you approve these rules and regulations? Well, let me tell you what the rules and regulations are intended to do. We want to enhance the tools we already have. We have tariffs and rules and regulations we've been using in contract. We want to enhance those tools. We want to provide for minimum bills, collateral, termination payments, terms of length of contracts in order to better enable us to address the load as it has continued to grow. And so to be clear, we have been making efforts to protect customers throughout. So it doesn't mean that prior contracts are bad contracts. It means as this load has grown, we need to continue to enhance what we're doing, which is what we think the Commission expects us to do. It's to not just sit on what we've been doing, but to continually look for the next best thing to protect customers.
Well, Brandon, wouldn't it be feasible to say, these are the rules right now, this is a suggested change? And that could be on one page, not 10.
Yeah, well, that's my response to their motion. Our actual filing was only about 2 pages with the backup showing exactly the edits we want to make. So we believe this to be a very simple
There are
filing.
rules, right?
Yes.
And there are changes requested.
Yes.
That's what we need to see right there.
Yes, and we have
don't
that.
need-
Commissioner, we have that in our actual filing. So I don't have copies enough for the entire commission of our original filing, but our original filing includes both the revisions as we put them in, as
I'm
well
sure that'll be on
as
my desk before Tuesday.
you will be on your desk, I think, today, sir, for you to review. But the point is, Commissioner, we are revising rules and regulations. The statutes allow for rules and regulations to be revised outside of a rate case. What we're trying to do isn't affecting rates in terms of changing rates today. But what it's intended to do is allow us to have those tools that we need to ensure that, look, consistently, I think we're all saying the same thing. We want to ensure that the large load customers, to the extent they are causing costs, both direct and upstream costs, that they're paying those costs. And that's exactly what our filing says is our intent. You know, there's the discussion that SCLC is making about needing to have a policy statement made as part of the decision here. And I caution you that you don't need to do that. And there's a couple of reasons. One, our filing says what the intent is. Two, your staff's recommendation says what the intent is. In fact, their bullet number 1 of their recommendation confirms what they understand the intent of this to be. So there's no need for any additional policy statement about intent. And I'll tell you that the negative of a policy statement, as suggested by SCLC, is that it does implicate cost of service. And there are several ways to interpret statements. And typically when someone asks you to make a policy statement, they have their own interpretation. Well, we haven't vetted that in a fully litigated proceeding. We haven't had the rate case where people can say, this is what this means, and you fully understand what you're adopting. And so there are avenues for SCLC, if they want to push forward with a policy statement as part of what they want in these future cases, they can bring that forward in a base rate case, where we will have a cost of service study. We have said in the 2023 RP update, we will provide you a full cost of service study addressing these particular customers for you to analyze and have all the facts and evidence you need to make a fully informed decision. We intend to follow through with that commitment. We'll have that for you. But any policy statement, if there needs to be one, needs to be made in that forum and not here today. There is no confusion about what we're doing, both from the staff recommendation and from what the company has filed. I didn't hear Mr. Scherer raise it. They did say they had concerns about Section General Rule A1, I understand from their motion that they are fine with the changes except for Section A1. And I think it may be back to the point Mr. Shearer was making about oversight. And I'll say once again, as the commission's pointed out in this discussion, Mr. Shearer, you have oversight. You've got the IRP, you've got the rate case. But in addition to that, in working with the staff, we're going to file the contracts 30 days after they're executed. So your staff will be able to review what we're doing in terms of these rule changes. We are going to file updated tariffs that will reflect these changes. And I'll tell you, we're doing that in part to make sure that customers who aren't necessarily customer choice customers, they may be eligible, but they may decide not to be customer choice customers, that they're aware within our tariffs that if they select a tariff, if they're this type of customer, a large load customer is 100 megawatts or greater, that they're going to be subject to additional terms and conditions in order to ensure the protections I know this commission wants. So we're doing all that. Your commission staff will have an opportunity to review all that. And we've been working with them to make sure that it's a good process. So I say all that to say we are taking the steps because we don't want, one, I can tell you for sure, we do not want at the end of the day to come to any confusion as to what we're doing and what the commission wants us to do. So we're working with the commission staff now to make sure that doesn't happen. But at the end of the day, the ability to change rates, the ability to address cost allocation, that's your ability. And that still exists, and that still exists in rate case forums where you would hear all of the evidence. In addition, when we talk about transmission costs that Mr. Shearer brought up, I'll say a couple of things about that, and I won't belabor the point. The QTS analogy is wrong. That QTS, I think Mr. Shearer in his filing suggested that somehow we didn't allocate costs for a line to QTS. It's not true. QTS, that line that was brought up by Mr. Shearer is not needed to serve QTS. And in fact, when we initially agreed to serve QTS, that line was not in our plans. That line is driven by other load growth and generation growth. And as you know, we're part of the ITS. So all that growth is not just Georgia Power's growth. So it's a much broader growth. So the example that SCLC is using is wrong, is number one, and that's in our petition, so I won't belabor that point. But the fact of the matter is, in terms of transmission growth, and what we're doing in that regard, you'll see that in IRP, which we'll file in a couple of weeks. And you'll have an opportunity to review and opine on that in that forum, which is the proper place for you to do that.
Did Fayette Data Center come to Georgia Power asking for service?
They were a competitive choice offer. I don't know how it started. So I don't know if they reached out to us
Was it
first.
competitive offers with Fayette EMC?
I don't know, Commissioner. I can find it out for you, but I don't know exactly the details of how the relationship started. I do know that they signed a request for electric service in May of 2022 with us, with Georgia Power. But the point there with the QTS is just simply that example is not a good, is unsupported that there's any costs that have been shifted because there have not been. And the record will show that. And we file with you, as you recall, we file our 10-year plan with you annually. And you can track how we're, assessing particular needs for lines in those plans. And it will show that QTS was not the driver of this particular line.
The minimum bill increases and longer contract lengths. Have you talked to any of these large load customers about this new plan and idea? Is it going to be well received?
We have. The great question, Commissioner Eccles. We have, and my general understanding, there may be someone who comes down here and explains to you, but generally the larger customers understand that these are requirements that are necessary to come to our jurisdiction and do business with Georgia Power Company. And so we've gotten, I think at this point, I'd say fairly positive, considering that these are additional terms and conditions for those customers' response to that. Not to say that you may one day get someone to, have the issues with it, but generally we've had positive responses.
And the security that we're going to be requiring in the future, I guess, could be a letter of credit, right? It could be a bond, different. How will that benefit ratepayers if data center reduces their load or leaves or goes bankrupt or something?
Same way Toshiba did with the plant.
It is, well, like I say, it's one, we'll have collateral requirements. It would be based on the quality of the credit counterparty. So, the larger the company, maybe parental guarantees. In certain instances where they're not as large and don't meet our credit requirements, might be letters of credit. The purpose will be to protect from the things that you just mentioned, Commissioner Eccles, if they don't have the ramps that they promised to have. That's the minimum bill. So part of the minimum bill is assure that if you tell us you need a certain amount of capacity and we plan upstream resources for that, that you're going to be on the hook for a given period term of contract to pay those costs, regardless of whether or not you actually use that power. So we're using both those mechanisms kind of together. The collateral requirements obviously are for those who, for some reason, if there was a reason where they were able to continue their business, that we could still collect those funds.
I mean, we approved this. There's members of the House over there, including the Speaker of the House, quite concerned about this. It's certainly something I think we need to communicate to them. We're taking action on this. We're protecting ratepayers. Y'all been in conversation with the General Assembly about this?
I will, unfortunately, Mr. Haswell's wife got in a car accident, so he's not here. He will have better understanding of what occurred with the legislature. I do believe we've been discussing with them this issue. I know that our legislative team has had conversations about data centers, exactly what they talked about, though I want to be careful about not saying it, that I know for sure. So we can definitely communicate that to you, Commissioner Eccles.
Thank you.
So some states are, a lot of other states are working on this, dealing with the large load growth particularly from data centers.
Yeah.
And some have developed unique individual tariffs for data centers. What you're requesting here in these rule changes is not that. It's just 100 megawatts of load or greater. So it could be a Hyundai or a large load customer like that, not just a data center. Is that correct?
That's correct. And if you look at how we wrote A1, it was intentionally written to give us some flexibility, understanding that different customers might have need to have different requirements. Now, that's not to say, Commissioner, at some point in time, if the commission thinks it's the right thing to do and the company believes it's the right thing to do, we could end up doing a tariff at some point in the future. But at this point in time, we think the rules and regs with the addition of the tariff changes that we're proposing to file with the commission after you hopefully vote for this and approve this Tuesday, we think is a good starting off point to allow us to do things we need to do for now. So yes, we believe this will be effective the way it is without particular data center tariff. But it doesn't mean we're not continuing to look at things. Like I think the one thing I want to make sure with the commission, it's a moving target.
I mean, it happened so fast, quite frankly, it caught everybody off guard.
Yes.
And it hadn't slowed down, has it?
No, and not here or in other places in the country. I mean, it's pretty
The
active.
door's knocked on because of capacity and reliability. That's the big issue. They're not knocked on the door for price.
I think, yes, I think that's right. I mean, I think they want to come to Georgia for a lot of reasons. And I think this commission is one of them, how they regulate this company. We have good, solid service, reliability to provide to them. Obviously, technology-wise, intersection of fiber is a big component of that too. Economic development generally in the state has been a big issue. So I think there's a lot of things that attract them here for sure, but electricity and reliability and service are a huge part of it. Yes.
Well, isn't it true, though, that data centers are fairly unique in the fact that some of these other large load customers, like we're talking about, may be interruptible type customers, where data centers, correct me if I'm wrong, cannot be interrupted?
That's correct. That's correct. They're typically 24/7 services because of the type of service they provide. They're expected to be online all the time.
But if one of these large load customers were, say, a crypto mining operation that met the requirements of the 100 megawatts, then most of them probably could be interrupted, correct?
I don't know enough about how the crypto operations work. I would think from the perspective of serving customers, they could be interrupted. I don't know technology-wise whether you can interrupt that operation because I'm not familiar with how the mining works. I don't want to say for sure they could, but you would expect they're not serving customers on a 24-hour basis the way a data center or an iCloud system would be serving customers. So I expect that's true.
Bitcoin companies pay for interruptible services, service in other states already. Interruptible service allows them to be able to be throttled based upon the demands of the grid at any given time. So it's very common in other states. I do want to just make mention of this, Mr. Chairman. I'm going to go ahead and tell everybody I want to hold this docket. Georgia Power has not discussed this docket with me at all. Bob and Jennifer, I haven't heard from y'all about it either. This seems like a pretty big rule change for us to be doing right now. That's got some major implications on our state's economic development and our overall energy system. So I'm going to hold the docket and I'm going to ask all parties interested in this item to please contact me.
Yes, Commissioner Pridemore, we can do that.
I think it's pretty obvious that we all share concerns about data centers, and the impact on everything we've been able to do right for so long here. And this is, like I said, this is new territory. And I just want to ask you one question. Do you think that this rule change protects ratepayers in the form that we've all been expressing our concerns about with regards to the changes that are included here? For instance, the changes regarding the length of the contracts. Explain that to me. I'm assuming that that's what we've talked about. I've expressed concerns about, well, let's just say that you serve a data center that's one of these huge mega, much even larger than 100 megawatts. And
Yeah.
what if the equipment in that facility becomes obsolete in 5 years and another state has offered them a tax credit bigger, or, things like that can happen and they just pick up and leave? That's what I want to make sure, that this will allow the company to recoup those costs no matter what happens.
Commissioner, that is exactly what we're intending to do. I mean, currently what we're trying to do with the rule change, particularly let's take the term of length of contract. Currently our tariffs, some of them have 3, maybe 5-year tops type terms. We're trying to extend that out to 15 years for these data centers, ensure that we're able to recoup those dollars, particularly as upstream costs. Direct costs we recoup from them, obviously more directly because those are costs that we directly assign to them. But for the upstream costs, for generation, transmission, and otherwise, we want to be able to ensure that we are able to recoup those. So that is what we're doing here. I think in part we're kind of overcomplicating what isn't intended to be complicated, which is why our filing was fairly short. These are terms and conditions you would probably expect to see in modern day business, and what these data center companies, quite frankly, probably see in a lot of spaces. But the limitations on us is that we're a regulated utility who has rules and regulations and tariffs that govern us. And so we need to adjust as we see fit to be able to address the challenges that you just mentioned, which is to ensure those cost recovery upstream costs does occur. And so that's what we're trying to do here. But at the end of the day, what I don't want to confuse this with is that the investment in, resources, the decision on resources, the decision on rates, decision on allocation of costs, those are all things that are done in other proceedings. And that's not what's locking you in here today. This is just to give us tools. And I hear Commissioner Pridemore, we will reach out expeditiously to her, but these are giving us tools that we really need to put in place as soon as possible to help us continue to want to take advantage of this growth, which we all know, as we explained in the IRP docket, 2023 IRP update is intended to put downward pressure on rates. This growth can do a lot to help customers. We want to be able to capture that. And so these are enhancements to help us capture that. We have tools, and these are sort of the enhanced tool set. And very similar to what we're doing, very similar to what's going on in other jurisdictions in terms of using these types of tools.
Mr. Marzo, based upon the gravity of this, I would expect Georgia Power to meet with all the commissioners and talk commissioners through this.
And I apologize.
Not just me. This is a lot to ask with no briefing and no understanding. Sorry.
No, and that's not, and I didn't mean to make it sound like I was criticizing your point, Commissioner Pridemore. I was just pointing out that there is a level of urgency, and we will obviously, I'll convey that to our team, and we'll make sure to any commissioner who we've not reached out to that we do.
I'll just tell you, the data center folks that came in here during the last session when a lot of this was on the table about the tax credits and so forth, and I don't know, maybe they'd heard me say some good things about it, but I had several of them come meet, and first question I asked is, I said, our job primarily is to make sure that y'all pay all your costs, your fair share, so to speak. And every single one of them said, we want to pay our fair share. So I want to make sure they do that. I'm not talking about 15 years down the road. I'm talking about now. Because they say they can do it. I mean, you look at the balance sheet on a lot of these companies, it's pretty strong.
Yeah, and I hear that, Commissioner. And once again, what we're trying to do is to ensure that what we typically show you, we do obviously BREM analysis and all that to ensure that when we do contract with large load, particularly competitive choice customers, that they are putting downward pressure rates, or they do meet the REM test requirements. We're just trying to lock that in And we are, obviously done a lot of other things. If you look at our contracts in 23 RP and what we've done from our normal contracting processes, we've also begun taking other steps even before that to lock some of those things in. So that, like I said, I'm not trying to downplay it, Commissioner, but this is a natural evolution of the tool set, but not something that's committing you to, like I said, a particular allocation of costs or rate case. Those are all things, policy decisions, those are all things that can occur in your normal traditional regulatory processes. But this is to give us tools, and I will convey to our regulatory team to double back with the Commissioner Pryborn, for you and others who may have questions about that.
But Brandon, we're not asking for anything or solidifying the fact that the traditional regulatory process is all that great. But if you guys want to make a rule change, you have to talk to the commissioners.
Yes, ma'am.
I don't know why that's suddenly novel.
Yes, ma'am, I hear that.
That goes back to my one page on say yes and say yes.
Yes, sir.
That's what only is what the change is requested. And also the word about recovering the cost. Companies recover the cost over time of their investment. Is that correct?
The company.
Did you mention?
Yeah, when that's talking about the length of these contracts, where they're asking us to have longer term contracts or more time to recoup the cost in the case that possibly they did not materialize or they leave.
That's right. That's right. It's to lock them in. That's why we have the key components here are minimum bills, termination payments. That is, if they decide to leave early. Minimum bills to ensure if they say they need a certain amount of capacity and we go out and do the generation transmission investments to make that happen, that they actually pay for those costs. Terms of service to ensure that for the terms necessary to ensure cost recovery of that we have them under contract, because currently our tariffs are typically shorter term. So trying to extend those terms. And then collateral requirements for those who, well, really for all, but for those, obviously for those who provide some credit risk, be sure that we are properly
There's no carrot hanging out there saying that they can recover those costs that they're putting up forward, right?
I'm not sure I follow, Commissioner.
It's gonna cost this much for interconnection. And then you've got a rate. And then is there a carrot out there that they can recover some of that cost down the road?
Oh, you mean recoup costs
Yeah.
based on, that's not my understanding of what we're trying to do now.
Okay, good.
No, we're not doing that.
It's a lot more than just interconnection. You got a lot of transmission involved in these.
Oh, yeah, that's why I
Yeah.
wanted to make sure that they weren't be able to recover that initial cost.
Yes.
Because my ratepayers, the plant Vogel, which I support strongly, their recovery is just using the kilowatts to come off of it.
Yeah, and that's right. And Commissioner, to be clear, as I think Ms. Shearer said earlier, their direct costs, which we absolutely recover up front. Those are the direct costs. You can think about sort of behind the fence facilities, anything that's specifically attributable directly to that customer. Then there's upstream costs. A lot of provisions we're talking about today are really around the upstream costs. So these are the costs for, generation, to the extent a customer causes additional generation pressure, that incremental cost is what we're talking about trying to recover. So, and that's what these provisions are intended to do.
All right, thank you. This item will be held for 2 weeks and it'll be back on our committee docket.
Bob, did you want to jump in there? You looked kind of eager at one point in time.
I'll just, a couple of comments. I mean, staff shares concerns that it's a fundamental regulatory principle that you want to allocate costs to the customers that are causing those costs. Staff also shares some of the concerns of the company in that as soon as these new rules and tariffs are in place, the company will have the ability to move forward with the customers. And we don't want new contracts in place that don't have these provisions to protect other customers. So there is a bit of a time element as well. That said, the situation is ultimately, from staff perspective, we got comfortable with it based on the conversations we had with the company. with the modifications that were presented in Dr. Deichman's presentation. And we see this as a good step. We don't want perfect to be the enemy of the good in this situation, right? So having said that, we understand exactly where SCLC is coming from. And we ultimately, the protection of other customers is high on our radar. But that said, we don't want to rush it. We want commissioners to understand the issues as well. Thanks.
All right, thank you. Anyone else wish to speak on this issue that will be held for 2 minutes? All right. Anything else for the good of the Energy Committee? All right, we'll move on to our administrative affairs.
Good afternoon, Commissioners. Item 2A, request for out-of-state travel for one EERE unit staff member to attend the 2025 Association of Energy Service Professionals Annual Conference and Expo in Phoenix, Arizona. March 10th through March 13th, 2025. ASEP is a leading organization for energy efficiency professionals. And this conference is the most widely attended in-depth gathering for energy efficiency professionals available each year. The total estimated cost of $2,474 will be paid pursuant to the June 28, 2023 MOU and docket numbers 44160 and 44161, therefore leaving no direct cost to the state.
Questions on this item? All right, Adam.
Item 2B, request approval to amend a consulting contract that was approved on September 17, 2024 regarding Georgia Power's 2023 Integrated Resource Plan update as it relates to data center load growth, revenue contributions, and any potential costs being imposed by the data center load growth onto other customer classes. This amendment is necessary due to the complexity of the issues being studied and analyzed, as been discussed here today. The contract amendment in the amount of $75,000 will be paid pursuant to the June 28, 2023 MOU and docket number 44280, therefore leaving no direct cost to the state.
Questions on this item? All right, Adam.
Item C is docket number 56008, notice of proposed rulemaking to amend existing Commission Rule 515-2-1-04, paragraph 4, applications, petitions, complaints, and filings, procedural requirements relating thereto. As we said in our rulemaking, the Commission continues to make technological advancements to its filing and electronic retrieval system in order to make it easier for interested parties to file documents with, retrieve documents from the Commission, and in order to improve the efficiency of the Commission in conducting its statutory duties. To take advantage of these advancements, it's necessary to update the Commission's existing rule. The proposed amendments to existing rule 515-2-1-0.04, paragraph 4, seek to provide interested parties the ability to make electronic filings to an electronic filing portal. In most circumstances, parties that make electronic filings through the portal will not be required to file any physical copies. However, the proposed amendment, the amended rule, preserves the ability of the Commission to require a party to file physical copies in limited circumstances where the Commission determines physical copies are appropriate. The proposed rule preserves the right of the parties to file physical documents in lieu of using the electronic filing portal. On December 3rd, 2024, the Commission approved the issuance of this notice of proposed rulemaking. Comments, data, views, or arguments on the proposed rule were due not later than January 9, 2025. On January 9, 2025, the Southern Environmental Law Center, Georgia Interfaith Power and Light, the Natural Resources Defense Fund, the Sierra Club, the Southern Alliance for Clean Energy, and South Face Institute jointly filed a proposed amendment to the proposed rule to include new language regarding public free access to electronic transcripts on matters of profound public interest. Staff recommends the Commission adopt the proposed rule in its current form as proposed. The proposed new language from the parties submitted relates to substantive questions of how transcripts should be paid for and whether parties have a right to a free transcript, while the proposed rule amendment relates more to the procedural mechanics of how parties file their proceedings. Staff would suggest that the issues raised by the parties not be included in this NOPRA, but that the staff study the issues raised, meet with the interested parties, and come back to the Commission with a recommendation on whether or not to change the current process, and if so, how to change the current process. If this ultimately involves a NOPRA, then a separate NOPRA would be initiated to address these issues.
So what are you asking us to do on Tuesday?
Approve the NOPRA that was approved on December 3, 2024 as proposed.
All right. Commissioners, questions? Other parties, questions? Comments?
I just wanted to briefly address the letter we submitted with the language about transcripts, and address the rule change generally. We are so excited to see this rule change. It is a terrific update and modernization of the system of filing. It will make access to the commission and the intervention process easier for everybody. So thank you for pushing this forward, and it's very well timed. We are also appreciative of staff's willingness to take the transcript issue up at another time and are comfortable with that not being a part of this NOPR. So don't have any objection to their recommendation in moving forward. Though in light of the upcoming IRP and the timeliness around the transcripts related to that issue, and just very briefly, that the issue is that the bill payers pay for the transcripts in contested dockets with utilities, certain contested dockets with utilities that they're required to file, but bill payers are the only ones who don't get access to them. Interveners don't get access. Only Georgia Power and staff do. Interveners have to pay quite a bit. It's about $1,000 a day for each intervener to get access to the hearing transcripts. So we're recommending, and frankly, from a lot of conversations we've had, it seems more like a procedural hiccup than it does anything that any party involved that I've heard of so far believes in from a policy perspective. So we're looking forward to working through that. But for the IRP, we would ask the staff if they'd work with us to incorporate it into the PSO on Tuesday to provide transcripts to the public as part of the IRP PSO, and future dockets can be handled through the process suggested by staff would be our request.
You're wanting to amend the PSO document that we have coming up for Tuesday? Is that what you're saying?
Yes, and just to include a note that transcripts could be made available to the public if, as part of that particular docket, as part of the process of that docket.
There's no commitment necessarily. It's just that they could be available. Is that what you're saying? Or that
That's
they
right.
would be available?
That they could be made publicly available. What that would entail, and if it doesn't administratively work, it doesn't administratively work. So the request really is to continue conversations between now and Tuesday and come back to you if it does administratively work. But what it would entail, the big issue is making sure the court reporter is appropriately compensated. Everybody wants to make sure they're paid for the incredibly hard work they do. And so that requires, of course, a contract conversation.
Yeah, can I have our staff respond to what she said about this amending for Tuesday? Is that
That's the first I've heard about the idea of amending the PSO, so I haven't given it any thought. The issues with transcripts is a little more complex. And I certainly understand the party's issue and concern. But the issue is we have one rule currently that applies to how transcripts are done and how they're paid for and how they work. And it applies to a whole range of cases, everything from GUFA rule NISIs to territorial cases to Georgia Power IRPs. And so if you start making changes, you have to make sure that you didn't just mess up how all of these cases are currently funded. It costs money to get the transcript. So there's always going to be an issue of how's it being paid for. And so I'm not saying it's an intractable problem. I'm just saying that it's something that has to be looked at sort of holistically to figure out, okay, how are we going to get a transcript in this case in a way that doesn't mess up how we fund transcripts in these other 90 cases over here.
okay? So you'll evaluate this and let us know before our vote on Tuesday
Yes.
that she's asking for.
Yeah, in regards to the IRP itself, we'll look at that. As far as like, if there's anything to change the entire process, I don't think we have time to do that before Tuesday. But we can look and see if there's any kind of like quick fix or something like that we could do for that.
Okay, well, let us know before Tuesday for our vote. Other questions on this issue? Anyone else wish to speak on this issue? All right, this item will be up.
All right, thank you. Item 2D is a consideration of amendments to the commission's official filing schedule. The rule, which we just talked about, references many times, filings have been made pursuant to the commission's official filing schedule. As we're amending the rule to increase for the technological advancements, we need to also amend our official filing schedule to reflect these changes as well.
Questions on this item? All right, this item is on.
Item 3A, request approval for one administrative unit staff member to attend the 2025 National Association of Regulatory Utility Commissioners Winter Meeting on February 23rd to the 26th, 2025 in Washington, D.C. The NARUC Education and Research Subcommittee, for which the staff member serves as co-chair, will hold their quarterly meeting to discuss training, educational opportunities, and recommendations for scholarships and interns. In addition, the remaining days of the conference will be attendance in various educational training opportunities, and the estimated cost to attend of $2,857 will be paid pursuant to the June 28, 2023 MOU and docket number 44280, therefore leaving no direct cost to the state.
Questions on this item? All right, this item is on.
Item 3B, request approval for one administrative unit staff member to attend the 2025 NARUC Winter Meeting on February 23rd to the 26th, 2025 in Washington, D.C. This NARUC Staff Subcommittee on Executive Management, for which this member also serves as co-chair, will hold their quarterly meeting. In addition, the remaining days will be for educational opportunities, and the estimated cost of $2,957 will be paid pursuant to the June 28, 2023 MOU and docket number 44280, therefore leaving no direct cost to the state.
Questions on this item? All right, this item will be on.
That completes it. Thank you, Commissioners.
Anything else for the good of this committee? And we had no public comment earlier.
Was there anyone that came in after the break that wanted to provide any comments?
All right, we're adjourned today. Thank you.
Thank y'all for bearing with us with the break too.